moment or two, and then we'll get started quite promptly. All right, Jen, whenever you want to say any introductory remarks or explain about the CLE credit, I'm happy to get started whenever you are.
Sure, just some quick housekeeping. If you are an attorney and you are looking for CLE credit, you will need to complete a CLE form after the training. We will email that to you. It's an electronic form. During the training, we will give 2 keywords. Those words you will have to put onto the CLE form. There's a box on that form where you can enter those 2 keywords. So just keep an ear out for those 2 keywords. We'll give one halfway through and towards the end. Again, just so if you're looking for CLE credit, very important that you keep an eye out for that email. If you gave us an email to register that you don't use, please put that in the chat. And if you have a separate email you'd like us to use, please let us know. Take it away.
Excellent. Thank you so much. So hi, I'm Erica Bryant. I'm Director of Community Engagement and Training at Legal Aid of Southeastern Pennsylvania, which really hides the ball because the practice area that I have been enjoying for the last 9+ years that I've been at Legal Aid has been all criminal record clearing. So this is the work that I've been able to do all day, every day for a number of years, and I'm very excited to share some updates about Clean Slate 3.0. I am joined by my colleague, Noelle, who I will let introduce herself.
Hi, my name is Noelle Gambale. I started with Legal Aid back in September. I graduated from Villanova in May of last year, so I started with Erica's team around October. I'm excited to be here as well.
Awesome. So Noelle and I will be talking you through. If you have questions over the course of our time together, please feel free to put them into the chat as we go. Don't feel like you need to hold them all until the end. Jen Pierce is going to be reading any questions you put into the chat so that Noelle and I can address them as we go. So don't hesitate. I really have no interest in talking nonstop for the next hour. I would much rather answer some questions. Also, I want to warn you all, I'm just getting over a cold, so I hope my voice is going to hold out, but if it starts sounding awfully froggy by the end, my apologies in advance. Also, just so you know, all of the resources are going to be shared with everybody after this meeting, including the recording. It usually takes, 45 minutes or an hour for the recording to be ready to share, but as soon as it is, we'll get all those resources out to everybody. All right, so I think we can go ahead and get started. So we'll be talking today about Clean Slate 3.0 and all of the new options that we have to be able to clear records. Noelle, if you'd take me to the next slide. Okay, so I know a bunch of us are in-house Legal Aid of Southeastern Pennsylvania staffers, but we also are joined by some volunteer attorneys. So I just want to take one moment for anyone who's not familiar to highlight that this training is being provided by Legal Aid of Southeastern Pennsylvania. We serve income eligible and vulnerable clients in Bucks, Montgomery, Delaware, and Chester counties, the sort of suburban collar counties around Philadelphia. We provide a variety of legal issues, everything from helping domestic violence survivors stay safe with their families to helping people with their public benefits issues, including, but not in any ways limited to, the criminal record clearing work that we're going to be talking about today. If anyone is interested in volunteering with any of our practice areas, feel free to reach out to me or Jen Pierce. We're always happy to connect you. In particular, if you're interested in helping someone clear a criminal record, reach directly out to me and I will be happy to make that connection. Next slide.
Erica, can you hear me?
I can. Hi, Sean. Are you joining us?
I'm joining, and thanks to you and Noel and Jen for putting this on. I think we may have some people still over in Teams.
Yes, Jen is working on that in the background. So she's diligently trying to help them be ferried over to the Zoom meeting.
Great, thank you.
Sure. So the goals of our CLE today are to talk about all the different options for how criminal records can be cleared. We're going to spend the majority of our time talking about Clean Slate 3.0 because that is what's new. But we want to make sure everyone is situated, understands how record sealing fits in to all of the record clearing options. We're also going to give you guys all of the updates about Clean Slate 3.0, what's new and different from the law's previous iterations, common issues and questions. We'll talk about how this impacts our clients. And then we've got a few hypos to help make sure, check all of our understanding. So that's the plan for today. Next slide. All right. Well, I think that means I'm going to turn it over to Noel, who's going to handle the next couple slides, but I'll be back with you in a few minutes.
All right, so like Erica said, we're going to sort of start more broadly and sort of situate Clean Slate in the broader sense of criminal record clearing. So we wanted to first talk a little bit about why it's so important to clear records. So I didn't know anything about criminal record clearing when I started with Erica in September. The most I knew was if you want a job and you have a criminal record, it's probably going to impact your ability to get a good job. And that was sort of where it stopped for me. And I think it stops for a lot of people. But I think, you know, it's a lot more nuanced than that. And it's much more broad reaching than just getting a good job. So as of now, there's an even bigger concern with jobs and running background checks. 87% of employers now run background checks. So that's a huge number of employers that are looking at criminal records in some level and capacity. And there are new protections for people, especially with Clean Slate, and we'll talk a little bit about that. It's becoming a little bit better for people, especially once their records are sealed, but it doesn't solve all the issues. And even with protections, as much as you want, there's still a stigma around criminal records and just seeing the names of charges pop up, whether they're even a charge or dismissed, it still holds a pretty heavy stigma. Outside of employment, criminal records also follow people. One of the more commonly known areas would be housing, whether it's an apartment or if you're an elderly person that has a really old record, maybe from the 80s and 90s, and now you want to be an assisted living home, or you need some sort of higher medical care, that can even keep you from getting into one of those places. Another big thing that comes up with criminal records is with parents and their kids. So if someone has an older criminal record and now, you know, they've sort of moved on in their life and they have kids, and they want to be involved in their kids' school, be a homeroom parent, or go on field trips, now that record can keep them from even volunteering with their own kids in their own kids' school. So again, it's very broad reaching, even admission into school. So we see a lot of our clients that want to go to nursing school and it comes up for them. And there's also a lot of prohibitions in general written into PA law for a lot of different types of licenses that records can keep people from getting those licenses. Sort of some examples that we wanted to throw out there that is an example of how this can come up with employment specifically. Let's say you have a crazy charge like a murder charge or an arson charge that's really old, you didn't do it and you were let go, the charge was dismissed, and you want to be a nurse. You didn't do it, but it's still going to show up on your FBI background check, even with a dismissed charge. So it is really important, even for people without records, this can even apply. And then another example that comes up a lot is people in different trades. So electrician's a good example. Somebody may have an extensive criminal record, but they're able to get a license to be an electrician's union. And unions will give out different jobs and go to different locations. Depending on where that job is, if it's at a school or a military base or somewhere with a higher level of security, they might not be able to take particular jobs even once they have the license. So it is pretty broad reaching, even when it seems like, okay, well, they can get the license. Well, maybe they can't do the jobs that the license allows them to do. So that's a little bit about why it's important. And the next thing we want to do is we're not going to get too focused on any of these other forms of record clearing, but Erica and I sort of wanted to situate you on where limited access fits in. So there's 4 main types of criminal record clearing in PA. The first one we're going to address is vacatur. We started with this one mostly because a lot of you may remember this from the last retreat last year. Shay Rhodes from Villanova came in and talked a lot about vacatur and their work that they do there. But for those of you like me that were not there, what vacatur is it's a very, very limited form of record clearing for a very limited number of people. It comes up a lot. It comes up only with human trafficking victims. So in order to have a sentence or a conviction vacated, you have to have been a victim of human trafficking. And then the conviction that you're trying to vacate has to be in a very specific subset of offenses. So once you are eligible with both of those things and you have your sentence vacated, then you can have it expunged. And then we move to expungement, which is the next level of record clearing, which is sort of the gold star standard of record clearing, where the record is completely gone, it's destroyed, it's shredded, it's nowhere to be found. It's not on public record, it's not on employment background checks, and it's also still not on FBI background checks. Again, it's very narrow who can have an expungement. Non-offenses or non-convictions can be expunged. People that are over 70 may have their records expunged. Summary offenses can be expunged after 5 years. And then something that's going to come up in a little bit is convictions that have been pardoned can be expunged. So then sort of the next step down is what we're going to go into a lot of detail about today, which is sealing a record. Sealing is also known as limited access, which is also known as clean slate. So those are 3 terms. We're going to try not to throw all of them at the same time, but sealing, limited access, and clean slate, all the same thing. What that is, it's a step down. It's available for more offenses than expungement, but it is less protection than expungement. So with expungement, where the record is destroyed, limited access, it's not destroyed, but it's basically locked. So the record exists, law enforcement has it, the courts have it, but the record's locked away. What this means is law enforcement can see it. It's not going to come up on public record search anymore, which means it won't come up on your standard background checks like checker, hire right, things like that. But for people that have a job where it requires fingerprinting or an FBI background check, it will still come up. So, and we'll talk a little bit later when maybe sealing is not enough for somebody, but they're not eligible for an expungement. And then finally, pardons are the broader and broadest sense of record clearing, and anything can be pardoned at any time. But, you know, the Board of Pardons has pretty specific recommendations on when people should apply, who should apply, and LASP has our own priorities for pardons as well. So again, that's sort of where sealing fits in the whole spectrum of record clearing. We're not going to go into these other topics today. If you have any questions about them, Eric and I are free to answer any of those after or at any point. But so this is all about limited access. So I'm going to pass it back to Erica to get into the heavy details of sealing.
There was one question before you move on. Do FBI background checks no longer list the charge with a notation that it was expunged?
So my understanding is that the FBI, of course, as a federal agency, they're not obligated to follow a state judge's expungement order, but that they very frequently do remove that information. And in fact, it's the Pennsylvania State Police they actually have discretion and the ability to remove an expunged case if that record that's been expunged is the most recent or the only record that that person has with the FBI. So in those situations, it happens, let's say, all but automatically. It's pro forma. Otherwise, my understanding is that the FBI is honoring expungement orders. Now, that question was specifically about expungements. The answer is different if we're talking about limited access. Limited access cases are still appearing on FBI background checks, and we're going to talk about that at length later in the presentation. Okay, so we're going to talk about limited access, clean slate, or sealing. I often call it sealing. So for the effort of not confusing everyone by using those 3 terms all over the place, I'm mostly going to be calling it sealing. Just so you know, that is the same thing as limited access and the same thing as Clean Slate 3.0. All right, next slide. All right, so when we start getting into the nitty-gritty of our analysis for what types of records are able to be sealed, certain convictions on a person's record are excluded, meaning that they themselves can't be sealed, but they don't necessarily impact whether I can seal other things on my client's record. Different convictions are considered more serious, and they are not only excluded themselves, but they might also be disqualifying for a client's ability to seal something else on their record. So I just wanted to define those terms because we're going to be using them a whole lot going forward. All right, next slide. All right, so here are just some of the major highlights about this law. So advocates had been hoping that there would be an expansion of what types of law records could be sealed, but it wasn't until just mid-December that Governor Shapiro actually signed it into law. And there was a 60-day implementation period for petition-based sealing. So that law goes into effect February 12th. And then later on, there is an additional wave of new records that will be eligible for sealing automatically. And the automatic sealing provisions go into effect June 11th. And we will go through at length momentarily what records are eligible for petition-based sealing and what records are eligible for automated sealing. But for now, it's just important for you to know you can start filing petitions February 12th. I know I have a number of clients who have records that we think should be automatically sealed in June, but we're planning on petitioning to seal them sooner because why not give the client that advantage? Another new element of this law is that for the first time ever in Pennsylvania, it allows nonviolent, non-sexual felony convictions that are graded at the lowest felony level. So either ungraded felonies or third-degree felonies, especially ones that are drug or property related, are newly eligible to be sealed. This is a watershed change. I cannot overstate the impact that this will have for our clients and our communities. It also, Clean Slate 3.0 also shortened the waiting time. So it used to be that you need to have at least 10 years after your misdemeanor conviction before that conviction could be sealed. That wait time has been reduced. So it's now 7 years to seal a misdemeanor conviction. The felony convictions that are eligible to be sealed become eligible after 10 years. And summary convictions can be sealed after 5. There are exceptions upon exceptions, but painting with a broad brush, those are the new waiting times. Also, one first-degree misdemeanor has been added to the list of first-degree misdemeanors that's eligible to be sealed, and that is first-degree misdemeanor terroristic threats. So that's just a very specific exception that's been added into the law. Next slide, please. All right, so here we are, right in the nitty-gritty. I warned you guys, there's only so long that we can avoid it. So we have this chart right here, which is covering what can be sealed automatically. Again, that's going into effect mid-June. The next slide is going to cover a broader universe of what can be sealed by petition starting February 12th. I honestly spend much more time with the analysis of what can be sealed by petition because usually I am in the situation of trying to see if I can file a petition for someone. But it's very important to know what can go away automatically. I think it's really crucial to be able to tell clients, maybe I can't seal your record right this second, but come back to me on this date and it can be sealed, but you'll need to file a petition. Or you don't need to do anything. The court should just get this off your record on its own as of a certain date. So the general rule going forward, starting June 11th, many qualifying drug felony convictions will be sealed automatically. What makes something a qualifying drug felony is very specific to the individual's specific record. So we are looking generally at people who have convictions for PWID, possession with intent, right? It's generally an ungraded felony. So ungraded felony related to drugs, no weapons, no sex, no, nothing else that would make it more problematic. But we have to do the additional level of analysis to see what sentence the defendant actually received. Because to qualify for automatic sealing, the maximum sentence has to have been less than 60 months, and the minimum sentence has to have been less than 30 months. So if you have a client and they had a felony PWID conviction from more than 10 years ago, you have to go back and check what sentence they actually got. Generally, that's often on the docket sheets, but I anticipate we'll be doing a lot of requesting of records from the court to find very old cases and see what their sentencing parameters were. All right, you also have to confirm that no restitution is owed on the case that you are hoping to have sealed. This is true for petition-based as well as automatic sealing. No restitution can be owed on that case. It is absolutely, though, okay if fees, fines, or costs are owed on the case. No problem, you can seal the record. It's just that there can't be any restitution owed. For what it's worth, the majority of cases in Pennsylvania never had any restitution. So this isn't a barrier for the majority of people, but for folks who have restitution, they need to know that has to be paid off first. Confusingly, payments don't always automatically go to the restitution before they are applied to fees and costs. If you have clients in that situation, let me know. I have a sample petition where we asked the court to make sure that the payments were allocated to restitution first. And I generally have been able to have not too much issue getting that granted. So that's a great option to know if you have a client who's able to make some payments, but really needs to make sure that money is being targeted to the restitution. Okay, also for automatic sealing, it has to be an ungraded misdemeanor or a second or third grade misdemeanor. No first degree misdemeanors get sealed automatically. You also have to have the wait time. I did already mention them in passing, but I'm gonna flag for you that all of these wait times start on whatever the disposition day is. So the date of the guilty plea, the date of the charges being dismissed or null prost, that is the date that these clocks all start. If someone isn't sentenced until well after the guilty plea, or even if someone had years of probation, all of that time counts toward their 7 or 10-year wait that they are required before they can seal the case. That being said, the 7-year wait to be able to seal a misdemeanor conviction and the 10-year wait to be able to seal a felony conviction, those waits are restarted if there is a new subsequent misdemeanor or felony conviction, which is not the case if what we're trying to seal is a summary conviction or a non-conviction. There, it is purely a matter of wait. There is no requirement around any subsequent convictions or arrests being disqualifying. Okay, then there are certain specific convictions that are just not eligible. So crimes of violence and crimes against the family will not be automatically sealed regardless of their grade. So if you're looking at a client who has, let's say, an M2 simple assault or an M2 endangering the welfare of children, they can be sealed with a petition, but they will not be sealed automatically. Similarly, for any of the specific offenses listed, anything that requires registration, anything that is a tiered sexual offense will not be sealed automatically. Similarly, cruelty to animals, corruption of minors. And then there are these disqualifying convictions. So these mean if someone has these anywhere on the record, they won't be able to seal something else. So if someone has ever had a felony conviction that's not a qualifying offense, not one of those drug felonies with the lower to middle range sentences, any other felony conviction means nothing for that person will be automatically sealed. Similarly, if they have 3 or more felony drug convictions, nothing will be automatically sealed, even if each of those qualifies to be sealed. It just has to happen by petition. Also, there are combinations of records that kick people out of the automatic sealing. They are all listed for you. So I am going to move on to the next slide. There we go. So I see a question in the chat asking if DUIs would be considered disqualifying. And that's a great question. It is, however, unfortunately, a confusing answer. DUIs run the gamut, right? They could be a misdemeanor, they could be a felony. And even within that, they could be all different grades depending on what the blood alcohol content was, depending on whether any other substances were involved, depending on whether the individual has prior DUIs, depending on how much damage or injury was caused, right? So it doesn't actually matter whether it was a DUI or not. It matters whether it was an M3 DUI or an F2 DUI. And then the rules follow exactly the same rules as they do for any other charge of that grade. So I hope that helps. If you know specifically the grade of the DUI you're concerned about, add that to the chat and I'll keep going. Jen, go for it.
I'm gonna do the first code word right now. So reminder for any attorney, legal aid attorneys, attorneys outside of legal aid, whether you are volunteering or not volunteering after the CLE, if you want to get credit, please make note of the first code word. It is CLEAN, C-L-E-A-N. I'll put it in the chat. And just remember to mark that down so that when you submit the CLE form, that's the first code word. Thanks.
Great. Thanks, Jen, for keeping us on track and making sure everybody gets their CLE credit. I appreciate it. Okay, keep the questions coming in the chat. Meanwhile, I am going to launch going through this chart, which reviews everything that can be sealed by petition. And I will try and highlight the distinctions for what is expanded eligibility that we can seal by petition that we cannot expect to have sealed automatically. So, general rule begins similarly. Any ungraded misdemeanors, second degree or third degree misdemeanors or summaries can be sealed by petition. First degree misdemeanors can largely be sealed by petition, but there are certain excluded first degree misdemeanors, which we'll get into momentarily. So anytime I see an M1 on a client's record, I always have to double check and make sure it's not an excluded M1, it's a permitted M1. Then what's very new and very exciting is that we've got a broad range of ungraded felonies and third degree felonies, which can now be sealed. But it is not all third degree felonies. It is not all ungraded felonies. It's only some. But importantly, it is no first degree felonies and no second degree felonies. Absolutely none. Within ungraded felonies and third degree felonies, we're largely talking about property crimes, theft crimes, and drug crimes. There are some other sort of potpourri ones in there as well, criminal mischief and trespass. But by and large, we're looking at theft crimes, which are the citation on the docket is going to begin with 39. And forgery and fraud, the citation, the statutory, it's going to begin with 41. So that is your sort of quick and easy way to figure out whether it is a felony that you can seal or one that you can't. All right, so then we're going to talk about wait times. They are the same wait time as automatic. So there's no, you can get this done faster if you file a petition. It's the same exact wait time. 10 years from the disposition date on a felony conviction with no new misdemeanor or felony convictions during that time. If there is a new misdemeanor or felony conviction, the 10-year clock is going to restart on the disposition date of the new case. All right, the 10-year clock, however, is not restarted if someone has a mere summary conviction or an arrest that didn't result in a conviction at all. That's fine. The 10-year clock continues unaffected. For misdemeanor convictions, the wait time is 7 years and the rules are exactly the same. Starts on the disposition date, restarted by a new misdemeanor or felony conviction only, not restarted by anything else. Summary convictions, 5 years, regardless of any subsequent interactions with law enforcement. All right, so now we've got to talk about what's excluded. For starters, we already covered no first or second degree felonies, no third degree felonies, except for the ones we just specifically went over. And also within the universe of first degree misdemeanors, we need to know that we can't seal first degree misdemeanors, crimes of violence, or crimes against the family. So again, I'm going to say if you have an M1 simple assault conviction, that cannot be sealed, but an M2 simple assault conviction can be sealed. Same thing with endangering the welfare of children. All
There's
right.
a question in the chat, Erica.
Great.
I think the question is for costs and fines, if they need to be paid for a petition to seal versus expungement.
So for a petition to seal, the fees, costs, and fines do not need to be paid. Restitution does. To answer your question about expungement is a little bit of outside the scope. I'm going to try and be quick. So I'll say the expungement statute and the criminal procedure expungement rules are silent as to whether or not money can still be owed on the case when the record is expunged. So it may become a barrier as a judge may be unwilling to grant the expungement because of the debt. A district attorney may object to the expungement because the money is owed. And then I've even had issues on the back end where I have a granted expungement order, but implementing that order is difficult to ensure because money is owed on the case. I'm actually in the midst of a Commonwealth Court appeal based on just that issue. So I could talk about that at length, but I am going to move on, and I invite you to send me an email separately if you want to talk about it more. Court debt is definitely one of my passion projects. Okay, all right. So for a first degree misdemeanor, we are going to make sure it's not excluded. As long as it's not excluded, then it can go. In the resources we're going to send out, we're going to include a spreadsheet that lists a whole lot of misdemeanors and will help you figure out whether it's an excluded M1 or not. All right, then we need to look at the disqualifying convictions. And this is where the real complicated analysis comes in for me. So bear with me, give me all your focus if you can, because it's really very fiddly. All right, so we already covered the default wait times. There are certain things that create a lifetime disqualification, and that continues to be if someone has ever been convicted of any first degree felony or they've ever been convicted of murder. They cannot seal anything on their record. So if I have a first degree felony for aggravated assault from when I was 19 years old, and 50 years later, I'm trying to get into assisted living and they won't let me in because of my aggravated assault, there is never going to be anything I can do to seal that or anything else. It's just a lifetime ban. That person would have to get a pardon or wait until they're 70 and they can expunge it. But for sealing, for limited access, for 3.0, there is no eligibility for them. Similarly, anyone who has a conviction where the maximum penalty, the maximum sentence that they could have received statutorily was more than 20 years incarceration, they are also disqualified from sealing anything on their record. Fortunately, there are not very many things where you could get 20 years that aren't already F1s or murder. So that ends up being a really, really, really narrow exception. What we see way more commonly is people who have a number of convictions on their record. And so we can still seal things for them, but they might need to wait longer than the baseline time of 7 years to seal a misdemeanor and 10 for a felony. So if over the course of the last 10 years, so starting at today's date and going backwards 10 years, they've had 2 or more first degree misdemeanor or felony convictions, then we need to wait until the oldest falls outside of the 10-year look back period. So if somebody has an M1 in 2010 and another M1 in 2017, they would need to make sure that the 2010 case is more than 10 years old, as well as making sure that the 2017 case is at least 7 years old from present. So it's a two-step analysis. Importantly, one clarification in Clean Slate 3.0 is that we are counting cases that have these convictions. We are not counting the individual number of convictions per case. So let me give you an example. If I pled guilty to 2 first-degree misdemeanor counts of writing bad checks, as long as they are on the same case with the same offense tracking number or OTN, those 2 counts will be combined for the purposes of clean slate eligibility analysis. So 2 convictions for M1 writing a bad check, if they're on the same docket, count as 1. Whereas if I wrote a bad check in 2012 and I wrote another bad check in 2016, had 2 separate cases with 2 separate arrests and convictions, they would be counted as 2 separate cases. I know that's confusing. I hope someone will ask questions so that I will have a chance to clarify if it is still not clear. All right. Also, you need to look at the last 15 years if the person has had convictions that are second-degree misdemeanors or higher. You need to wait until all but 3 of those fall outside of your 15-year look-back period. And same thing, we're counting number of cases with those convictions, not number of charges that were convicted upon. Similarly, if someone has had a felony conviction that is specifically for a crime of violence or a crime against the family or any of those sort of gun or sexual-based charges, you need to wait for that felony conviction to be outside of the 15-year look-back period. Okay. Do we have questions? All right, seeing none, I'm going to say next slide. Okay, so here are some common misunderstandings. Hopefully I've already gone over them with you, but we're just going to try and highlight them one more time. Owing money is okay. It's only restitution that is a problem for sealing. There are totally different rules for automatic versus petition-based sealing. This is a great point and one I had forgotten to make. So several years ago, the expungement statute was interpreted by the Pennsylvania Supreme Court in a case Commonwealth v. Julian starting with a G. And it said that in order to be able to expunge a summary conviction, any subsequent 5-year period that was free of arrest was adequate. The 5 years didn't need to immediately follow the conviction date. So if someone had a conviction in 2010 and another in 2011, if they've had nothing since 2011, they certainly have the time that they need. That logic has been applied in an unpublished decision, Commonwealth v. Harper, to also apply to limited access analysis. So it is not published, but it is the best I have to go on. And I do always sort of analogize to that Pennsylvania Supreme Court case, Commonwealth v. Julian, to sort of make it clear that if I'm representing a client who has, let's say, a misdemeanor conviction from 2010 and another one from 2014, as long as they have the time that they need from their most recent misdemeanor conviction, that should suffice to allow us to seal both cases. Similarly, if someone had a misdemeanor conviction they wanted to seal from 2010 and then another one from 2019, they have the 7 years that they need between 2010 and 2019. And so that, in my argument, would also be adequate to result in a court granting the record to be sealed. All right. We can, in fact, seal second-degree misdemeanor, crimes of violence, and crimes against the family, just not first-degree misdemeanors of that ilk. And then the clock runs from the disposition date, like we did already cover. Whew. All right, that was a lot to get through. I know it's confusing. We will absolutely have hypos to help with the application. But I'm going to turn it over to Noelle.
Okay, so that was a lot of the detail-oriented part of limited access and sort of who gets to get records sealed and all that. But we then sort of want to take the lens back and talk on a more broader scale about, okay, so that's awesome, but then what does this do for the client? And sort of what's the application of it? So the first big part of limited access, which we sort of already touched on, is that now the records are not publicly available, which is great. And because they're not publicly available, that also means it's not going to show up on most of your background checks. So like Checker, HireRight, Lexis, all those types of regular old background checks that most employers do, now it won't show up on there. And so our clients can then say that they don't have a record, which is huge. So they don't need to disclose that record. Where this comes into play, though, is they still show up on FBI background checks. So, if that employer has not been granted, that they need to have an FBI background check, then our client does not have to disclose. But things are a little bit different if they are required by federal law to consider sealed records. So sometimes employers, even if it's not an employer that we normally think of that needs an FBI background check, will still run them. That they aren't allowed to consider sealed records. For some employers, federal law requires that they do consider sealed records. And most often you think of schools, offenses related to children, endangering the welfare of children. Those are the types of employers that, even if the records are sealed, may have to consider them by federal law. And so, and sometimes, going off that, sometimes Clean Slate's not enough. So there are a lot of great protections that are coming from Clean Slate. A lot of increased protections than there were, especially around sealed records and considering them, but sometimes it's just not enough. So for us, what we do a lot of time when we're having the conversation with our client around sealing is finding out sort of what are their end goals. Are they in nursing school and trying to apply for jobs? Are their goal is to be a teacher and they want to be in public schools and work with kids? So that's really what we look out for, looking out for those types of jobs where somebody's going to need their fingerprints run. And it's cool if we can get it sealed, but it's not really going to help with that type of job. So if you have a client that you're having a conversation with about limited access, I think it's always a good idea to have the conversation about sort of what their long-term goals are, so you can best sort of decide what makes the most sense to spend everyone's time on. So that's where, if it's a job where they're going to need it fingerprinting or FBI checks, that you're going to maybe start talking about the pardon process. We're not going to sort of get into the nitty-gritty of how pardons work, but it's a long process. But for some clients, it really is worth it because pardons can then be expunged once they're granted. So having those conversations with your client, aside from the math and adding up all the convictions and the dates and all that, is super, super important to knowing sort of how to go forward. So some other instances that pardons may be necessary, not just in the employment aspect, is when it comes to immigration. So we don't see a lot of that in our work at LASP, but sometimes it does come up where people need records expunged for immigration purposes. Other times, if you have a client that's looking for a job that's out of state, protections around criminal records are very, very different in surrounding states than they are in Pennsylvania. So even if they're not looking for the type of job that we would maybe think for Pennsylvania, in needing FBI checks, it might be worth asking, sort of where the job is, because that could change your answer in terms of what maybe makes the most sense. So we threw a lot of information with you about details and things like that. So now we sort of want to give you the chance to apply everything we've been telling you, so maybe the math makes a little bit more sense. So I'll pass back to Erica.
Yes, absolutely. Thank you. I'm also going to just highlight a question in the chat because I think it was a really good one. Crystal, and also, hey, Crystal, asked if we ever submit both a pardon application as well as a petition to seal a record. Yes, absolutely. There's no reason that we can't get both relief for the client. Pardons, like Noelle mentioned, they take years. I've had clients wait 4 years for a pardon, even from the time it's submitted until they have a final decision on it. Whereas we can usually get a record sealed in 4 to 6 months. So if a record is eligible to be sealed, we would always try and get the petition for that submitted right away. And then if that's not going to provide the relief the client really needs, ultimately, then we would also be working in the background on the pardon. Excellent question. Thanks for asking it so I could have a chance to say that. All right, so now we're going to start talking about our hypos. I admit that it's a little bit complicated because we're going to give you the hypos and then you're going to need to figure out whether we can seal it, and you will only be able to see either the hypo or the chart one at a time. So Noelle, next slide, we'll spend some time going through the facts. I'm going to encourage you to take notes of the relevant details so that we can then switch to the side to the chart. All right. In January of 2012, Aaron pled guilty to possession with intent to deliver an ungraded felony. All right, ungraded felony is key number 1, right? Plus, it's PWID, so it's a drug felony, and it's from January of 2012. So we need to know the date of the conviction and the grade and the content of the charge. He was sentenced to a minimum of 18 months and a maximum of 36 months confinement. Since then, he's had 2 traffic tickets, but no other criminal cases. He owes a little over $2,100 in fines and costs, but he doesn't owe any restitution. He hasn't had any ability to make any payments on his court debt. All right, so take notes. Anybody feel brave before we flip to the chart? Anybody have any guesses or thoughts or questions, or you feel like you need more information that we haven't given you? Also for this, please feel free to unmute yourself and just ask if that's easier, or use the chat, whichever you prefer. All right, I will take it to the chart. Noelle, if you would switch us to the petition-based sealing chart, thank you. And I'm going to warn all of you that, oh, hey, Melina, you think we can seal maybe? I also think we can seal maybe. Anybody else have one thing that they want to figure out whether we can seal this case? What's one thing you're going to look at? Y'all think that I will just give you the answers. See, I will always wait somebody out. I will just lean into that awkward silence. Thank you for that question, Mike. Yes, ungraded felonies are their own category. And you can see here, the general rule is that third-degree felonies and felonies with no grade listed, or ungraded felonies, right, are qualifying if they are a drug felony. Noelle, can you highlight this section for me? So it is a drug felony.
Is there a way to highlight on Zoom? There.
No, I thought there would be because you were screen sharing, but maybe not. If you can't, don't worry about it.
No, I got it. We're good.
Okay, so to Rob's question, or to Richard's question, great question. This is this person's entire record. So there are no disqualifying convictions, right? So we don't have to worry about that, but you are right. That is absolutely a good element and a necessary element. So we know it's an ungraded felony, which is tentatively okay. We know there are no disqualifying convictions. So then Laurel flags that she would try and figure out if it is a qualifying felony. So, okay, we know it's a drug felony, but we also need to figure out whether the sentence is makes them qualified. So the hypo, I'm just gonna tell you from memory, the minimum sentence he received was 18 months and the maximum was 36 months. And in order to seal a drug felony, we need the minimum to be 30 months or less and the maximum to be 60 months or less. So his sentence is less than what it has to be. It qualifies. And then the last piece of it is how much time has gone by, right? Because we need at least 10 years. That case was from 2012 and we haven't had anything since. We can seal that record for him. In fact, his record may very well seal automatically. Nobody asked any questions about restitution. I'm going to assume that nobody asked us questions because we made our point that it doesn't matter that he owes his fees and his fines and his costs, or that he hasn't made any payments because he doesn't owe restitution. And that's all that would limit him from sealing his record. Okay. Noel, I think you're up for hypo 2.
All right. So let me click back. Oh, sorry. Now the highlights are showing up on the screen. That's okay. So for the second hypo, in 2009, Rosa was convicted of an M1 terroristic threats charge. Rosa did not owe any restitution on this charge. In 2011, Rosa was convicted of an F2 fraud charge. She owes $4,000 in restitution on the 2011 charge, but no other court costs. And since then, she has had no other charges. And we'll tell you now, for the record, this is her full criminal record, is these 2 charges. So the question is, can she seal the 2009? Can she seal the 2011? Can she seal both? Or can she seal none? So I'll do like what Erica did, take a minute, sort of write down, look at what you think are the most important facts. In this case, pay super attention to the grades in this one, because we have sort of one of the weird special rules is going to come into play. So I'll let you guys take a minute, and if you want to throw in the chat anything on here that you think is important to flag, and then we can go back to the chart. Question from Sean. That is a good question, Erica, if you want to tackle that.
Sure. So yes, you're right. The reason that we are sort of logistically, it's so easy to seal cases regardless of the court debt is because the court still has those records, so they can still keep track of the debt. Clients can still make payments on the debt. It's just not everybody's public business where those payments are getting made.
All right. So Joe, one of our interns who's tuning in, threw in the chat that he's worried about the F2 conviction, which sounds on point, Joe. So I'm gonna go back to the petition-based sealing. So Joe flagged the F2 from the 2011 charge. So I think let's start sort of talking through that. So Joe is right. The F2s are excluded convictions. So in that sense, we know that the 2011 as its own is not going to be eligible to be sealed because of the grade. But are there any other, let's turn then to the 2009 charge. And is there anything anybody sees with the 2009 charge that is giving them leaning one way or another?
Hey, Noel, remind me what that 09 charge was?
So the 2009 charge was an M1 terroristic threats charge.
Anybody remember either of us saying anything about terroristic threats, M1s?
Okay. All right.
Yes, Joanne Curley for the win. Rob, you are right that Pennsylvania does not like terroristic threats. However, terroristic threats M1 has been added in, so we can now seal it.
They like a little
And
bit more.
right. I will say the most recent client I have spoken to who has a terroristic threats conviction, it was because someone had beaten up her son and she went to the school and yelled at them about how they weren't protecting her child. And she was convicted of terroristic threats. So, you know, I think it's one of those things where it sounds hugely stigmatized. And sometimes it is, you know, the facts are particularly bad, but it often is a charge that sticks. And when you read these police reports, you realize that the facts just do not match with the stigma and the suspicions that we would all have about what the underlying behavior actually was. So now we are able to seal it. And Joanne, your analysis is perfect. Thank you. You're right that because there's no restitution, the money doesn't matter at all. So we can in fact seal that case. I am supposed to be taking it over from Noelle for Hypo 3, but I think we are just about at time. So you will all get the third hypo with the materials. And if anybody is interested, please feel free to email me what you think the answer is or what questions you have, and we'll get to it. Otherwise, I think, Noelle, we can just skip to the last slide so everyone can see our contact information so you know how to follow up with us going forward. Excellent. And yes, Jen Pierce, feel free to interrupt me.
The second code word for CLE credit is slate. So clean was the first one, second one was slate. Keep an eye out for the CLE form, make sure to complete that and include the code words to receive CLE credit.
Yes, thank you so much, Jen, and thank you so much, Noelle, for putting this on with me. If anybody has questions, you know, we've got 1 minute left. I'm also happy to stay a few minutes late. So feel free to unmute or add them to the chat. All right, hearing none, I think that pretty much wraps it up. But thank you all so much for coming, for taking the time. If any of your colleagues were lost in the Teams meeting, feel free to let them know. We'll share the recording with everybody.